Reopening, renewal, policy expiration, and other COVID-19 insurance issues to be aware of. As businesses begin to reopen to the public and bring back employees and clients and vendors are preparing to visit business sites, there are some other critical COVID-19 insurance issues they need to be aware of. And you might be thinking of a future business interruption claim caused by COVID-19 or another health crisis, but you should also really consider the impact on your commercial general liability insurance policy, your CGL policy. And that protects against third-party claims. So the most frequent example I give is a restaurant serves a meal to a customer. The server or one of the cooks may have, had actually COVID-19. The customer becomes ill and suffers medical damages or worse. And then either the customer or their family makes a claim against the restaurant, saying, "Hey, you caused this medical problem, and you're responsible for it." So that triggers what a business normally has is their CGL policy, and under that policy is a term defined as bodily injury, and the bodily injury coverage is sometimes there's an exclusion that goes against that coverage for losses due to virus. So just imagine in this COVID-19 world, if you're a restaurant, you have that type of policy, or obviously you're going to have a CGL policy, and you have that exclusion. So the number one thing you need to do is either you need to do it, your insurance broker should for sure be doing it, or if you're not comfortable reading your policy, you don't have access to a broker, then you need to lean on your attorney to do it, which is look for the standalone, look for this language, look for a standalone endorsement. Sometimes these exclusions are part of a standalone exclusion for bacteria or fungus, or part of a microorganism or contaminant exclusion. And then what you need to do is, in order to get ahead of it, you need to reach out to your insurer and say, "Hey, I want to make sure I have coverage for these potential type claims." And then if they say no, then you need to do your best to try to get coverage from a new provider. Remember, even if you're mid-year in an insurance policy, you can always cancel that insurance policy and get reimbursed for anything you might have paid in premium going forward for any future part of the term, and you can switch carriers. And I'll get into some of the issues regarding getting new coverage in the next few slides. Also consider, in relation to your CGL policy, any pollution exclusions, because those will potentially be used against you by an insurer. Some practical concerns when you receive a notice of a claim of someone saying they were injured by you due to COVID-19, whether it's, like I said, a customer at a restaurant, but think about, even a client at your law office, God forbid, or dental office or somewhere like that. You need to start a written investigation immediately. You need to alert your carrier immediately. I would alert your broker immediately, your attorney immediately. Usually clients alert the broker and the attorney in the same email or phone call. Do not wait 24 hours. I hope I've expressed the urgency enough. I'll move on. There's also an impact that you should think of when reopening on directors and officers, errors and omissions, and other professional liability insurance policies. Claims could be made against managers, directors, officers, or professionals for failure to make decisions to make the workplace safer, make your offices COVID-19 free for purposes of guests, whenever that happens. Ensuring a safe workplace for your employees. As I just mentioned, there are some other issues that come up when you're renewing or getting a new policy, or your old policy has expired. And at a minimum, I'm just going to lob the softball issue out there. Be aware of any new virus, pandemic, or COVID-19 exclusions. It's an interesting time right now because insurance companies, as you know, are fighting, and almost every insurance company, I'm going to guess, within the year that has written a business interruption policy in the United States will be subject of some type of litigation, or will be impacted by some type of litigation. So, the question becomes, if I'm an insurance company, do I now write a new policy or a new exclusion in my policies for future COVID-19 issues? So it's, without a doubt, COVID-19 is not a covered issue. Or if you have COVID-19, if you want COVID-19 coverage, you need to pay an extra exorbitant premium because of the loss could be so big. Well, that creates the issue of impacting all these current lawsuits you have out there. So policyholders could therefore, just theoretically speaking, could therefore say, if you're changing your insurance policy going forward, that means your old insurance policy, all the ones that are stuck in the lawsuits, but that are subject to class actions, that means there was coverage. So it's a very slippery slope here. I would not, I'm not envious of being an insurance company these days. On that note, the ISO, as it's commonly referred to, which is the Insurance Services Office, is something we should talk about. And that's a private company that serves the insurance industry, the insurers directly, the reinsurers, the agents, the brokers, the regulators, and they develop model forms. They've already rolled out 2 advisory forms that would provide coverage, limited coverage for COVID-19 going forward. We don't know, I have not seen that actual form being adopted by any carriers yet. And it's unclear what they're going to charge for that type of coverage, and what coverage is going to be, what's that coverage going to look like. I've included a link here that you should utilize for any changes, any up-to-date revelations on that issue. But lean on your broker in that instance if you're renewing or buying new insurance or need to get new insurance. And then another issue that is really dear to my heart, and I know you might be thinking that you feel sorry for me that insurance issues are dear to my heart, but I tell businesses almost on a daily basis to make sure they look at their claims-made coverage policies. And what is claims-made coverage? Well, this is something you find in professional malpractice liability, sometimes D&O, E&O, fiduciary liability. But most times you find claims-made coverage in employment practices liability. So in this post-COVID world, where COVID-19 world, where employers are issuing layoffs because they can't support their staff for whatever reason, or some employees may think or may actually have a claim against their employer saying, hey, you shouldn't have fired me or let me go. You should have fired somebody that was, more junior to me, or whatever the reason that person has. Maybe they say they were discriminated against. Well, if that type of claim, you receive that type of claim, and that might emanate in a letter by that employee, that may be from their attorney, that might be by an EEOC complaint. Here in Illinois, the city of Chicago has its own enforcement branch protecting employees, and you can make claims via the city of Chicago. And in those settings, you need to alert your insurer immediately, because claims made policy, unlike the property insurance policies we've been talking about, you have to make the claim within the policy period. In other words, if today is May the 12th, and you have a claims made policy, that an employment practices policy that expires on May the 15th, and you receive a letter today on the 12th that somebody's going to be suing you for discriminatorily discharging them, then if you wait until the 16th to make that claim, in some policies, that claim is something that is going to be denied because it wasn't made prior to the 15th. In other words, the effective date of the policy was May 14th, 2019 to May 15th, 2020. If the claim doesn't get into the insurance company's hand before that expiration, and you knew about the claim, it could potentially be denied. Now, there's another issue about extended reporting that's in a lot of these claims made policies. So maybe take a deep breath, lean on your broker, lean on your attorney, if your broker is not around, to find out what needs to happen. Sometimes there's also a situation where you think somebody's going to make a claim, and maybe they haven't articulated it clearly, like, I'm going to sue you or I am damaged, and you have a claims made issue. You should be aware of what is called a notice of circumstance, and strongly consider filing a notice of circumstance, or writing a letter, or having your broker or your attorney write a letter to your insurance company saying, I don't know if this person is going to actually sue me or file a claim or further pursue this, but this is a notice of circumstance. And what that does in a claims made policy is that hopefully and should make a retroactive claim within the policy period, meaning if today on May the 12th, you send the notice of circumstance and your policy that's expiring on the 15th, but you actually don't get the lawsuit for 2 more months, you shouldn't be denied that claim because you already told your prior insurer within the claims made policy. So now that I've bored you on claims made issues, also think about, changes, if you're renewing your policy or you're taking your policy to another carrier and say, oh, I had all risk coverage with Hartford, and now I'm going to, the Hanover Insurance Company, and you think, oh, I'm covered in that, with my insurance unicorn, as I've called it in the past. Well, all policies are not the same. So, especially among carriers, even within carriers. So make sure you understand your policy, get it in writing. I can't urge clients enough to get policy interpretation and coverage opinions to the extent you can. Insurers are reluctant to say, here's my here's a fact scenario. Do I have coverage for it under my new policy? My advice, again, lean on your broker, and if your broker's not there, you can lean on us or a qualified attorney.